One of the most common questions I get asked by people who are getting ready to file for divorce is who gets the stuff. In California, that's determined by what we call community property. And community property law tells us that everything acquired during the marriage by either one of the spouses belongs 50-50 to both. This means earnings, this means stuff you purchase, this means your bank accounts. Now, there's some exceptions to community property law, but that's for another video. So let's look at a couple common situations. What about where one spouse owns something before marriage? Well, that doesn't become community property unless they wanted to and they have to do certain things to make it community property. What about retirement plans? The part of the retirement plan earned during the marriage is community property, even if it doesn't pay out for years and years later. What about credit cards? Credit card debt, even if the other spouse did not know about them, are community property, and they have to be divided. Once you've figured out what all the community property and all the community debts are, then you can either negotiate with your former spouse on how to divide them in half. You can use your lawyer to help you to negotiate how to divide them in half. And then if you go to trial, the judge isn't going to negotiate with anybody. The judge has to order that all the property be sold and then the money divided in half. So it's always best for people, I think, to go ahead and try to figure out with their former spouse or with the help of their lawyers how to divide the property before going to court.